afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who have joined us early, thank you for waiting patiently. While we wait for the session to begin, we would like to share a short video about our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Breaking a Deadlock Between Co-proprietors of Land in Malaysia. My name is Ray Shan, and I'm a pupil in Chambers with Mao and Associates, and I will be your moderator for today's sessions. Before we begin, allow me to briefly introduce our firm and the work that we do. Mao and Associates is a mid-sized law firm founded in 1985 by Dato' Mao and Kwai. Our able team today consists of 31 lawyers and a support team of 33. Following his retirement from the Court of Appeal bench in 2015, Dato' Mao and Kwai served as a consultant with the firm. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relation team, and a department focused on servicing the needs of individuals and families. Our practice group indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talks is part of our Mao and Kwai online talk series. By way of background, we have been organizing monthly lunch talk at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we've moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require specific legal advice in relation to a matter, please contact us for complimentary legal consultation. Further details will be provided at the end of this talk. We have two speakers for today. Allow me to introduce our first speaker, Mr. Joseph Kaur. Joseph Kaur is a senior associate in our dispute resolution department. He was admitted to the Malaysian bar in 2020. Joseph graduated from the University of Malaysia in 2019. His area of practice includes land dispute, corporate and company matters. Our second speaker is Ms. Kitana. Kitana is an associate in our dispute resolution department. She was admitted to the Malaysian bar in 2025. Kitana graduated from the Northumbrian University in 2020 and later completed her bar professional training course at the same university. Her area of practice includes wills and probate, as well as land and disputes. In today's talk, Mr. Joseph Kaur and Ms. Kitana will be speaking on understanding the right and limitations of co-proprietors under Malaysian land law, common disputes and practical strategies to resolve deadlocks, legal consideration for terminating a co-proprietorship, and court proceedings, procedures, evidential requirements, and available remedies. We will then conclude with a Q&A sessions. With that being said, I will now pass it on to Mr. Joseph.
Thank you, Ray, and good afternoon, everyone. Thanks for joining us this afternoon for our talk on co-proprietorships. in Malaysia. I'm not sure if anyone here is still suffering from food coma, like I'm slightly under the influence of, but I'll try to make it as interesting as possible and not go through bland and tedious technical things. So imagine a situation, right, where you have this beautiful house, large house in a prime piece of residential land somewhere in Malaysia. I created this image via ChatGPT. Looks great. Anyway, imagine you have this large house. It was a family house. It was there since the 1800s, has been passed down throughout many generations. Well, eventually it came to two people, and it was held by a prominent Baba Nyonya family, one of their heiresses, like, the recent news about Genting and all that. Well, it was then this prominent lady passed away and leaving this house to her two sons. Her two sons are called Brandon and Jaden, for example. All right. And one day, Brandon and Jaden couldn't see eye to eye anymore. And one wants to keep the house, one wants to sell off the house. Now, what do? Can they do so? Can one person insist on selling the house while the other does not want to? Can one dispose of half the share of the house? Can they split the house in two physically? We'll find out later. Imagine another situation. You have a piece of prime industrial land inherited through the family as well. Or one day, you and your business partner, all right, decide to purchase a piece of prime industrial land to start the business. But because at that time you didn't have a company yet, at that time you don't have a Sendirian Berhad to hold this land, and you're just beginning to start off this business. So you told your friend, hey, let's purchase this piece of land, and then eventually we will inject this piece of land into the company as starting capital or starting asset. Unfortunately, before the business could start, you and your friend ended up in a huge argument about how the business was going to run and decided not to proceed. Now, the both of you are stuck with this land, a huge bank loan. You can't decide what to do. One person wants to sell it to A and the other one wants to sell it to B. Different prices. How do we do it? This is the story of Brandon and Jaden, for example. Can one person unilaterally sell off the land? And let's say because of the situations, the land is split. Brandon and Jaden both hold half of a share in the land. So Brandon has half, Jaden has the other half. Can they split the land in two? Who owns which part of the land? Does Brandon own the left side and Jaden own the right side? Or is it this situation where they both own the entire land together? We will look into this situation as well. Or in the worst case scenario, you have a piece of land or piece of immovable property that has been inherited for so many generations, you end up with so many people who own the same property. We have Jaden, Kaden, Aiden, London, Aiden, Mutuden, Akauden, Brandon, whatever. What is the position? So I will be explaining the legal framework of how this works. And then I'll pass it to my colleague, the wonderful Kirtana, to take everyone through a few case laws or a few reported judgments where the courts have dealt with these issues and how do the courts deal with it. So let's cover the framework. Let's cover the foundation and the basics first before we go into the case studies, all right? Now, co-proprietorships, meaning multiple ownerships of the same piece of property, is mainly governed by Section 342 of the National Land Code. The National Land Code is a piece of law or a piece of legislation that essentially governs land and most land and immovable property. So we will be using the word co-proprietorship a lot. And what it means is the holding of alienated land by two or more persons or bodies in undivided shares. Now, it says here, two or more persons or bodies, because in law, not only people can hold land or not only people can have land, companies and other statutory or legal entities can hold lands as well. Okay. And the crucial word for everyone to take note of here is the word undivided shares. Because while you have half, and I have half, it's undivided shares. All alienated land, when we say alienated land here, all it means is that it's private land now. So all private land that belongs to two people or more is held by them as co-proprietors, unless they are registered as trustees or representatives. This distinction will come in later. For now, all we have to know is that when it's land and there are more than one owner, all of them are co-proprietors. So what is a co-proprietorship? Under the National Land Code, co-proprietorships refer to, like I explained, land owned by two or more individuals or entities. Essentially, they own a distinct and divisible share of the property, but the law does not specify which part of the property they own. So like the piece of land that I showed just now, if it is held under one title, when I say one title, I mean one grant, okay, one title number. Every piece of land or every piece of immovable property has a title that's registered with the land office. So you have your grant, just like how when you buy a car, you have your grant that's registered with JPJ. When you have a piece of immovable property, land, house, it's registered with the land office. So every piece of land has a title. And under the title, if there's more than one owner, then it is basically owned by the two people, but without any determination of which part of the land they own. Now, can the co-owners later partition the land? Yes, they can. But until the land is partitioned or subdivided, the co-owners remain co-owners of the whole land, meaning I own half a share, you own half a share, but we own half a share of the whole land. It does not mean that I own the top, you own the bottom, I own the left, you own the right. It does not work that way. In situations where there is trusteeship, then it's different. Because they hold the land on trust, they are not owners of the land. But we can disregard that for now, otherwise you overcomplicate matters. All right. Shares are deemed equal unless different proportions are specified in the registered document of title, meaning if it's owned by two people, each will own half a share. If it's owned by three people, each will own 1/3 of the share. It is very unlikely, though exceptions do happen, but almost never does, in a normal situation, we will not have someone owning more than the other person. It's usually divided equally, all right? And co-proprietors can apply for partition of land with certain conditions, as we will see later. Each of the owners is entitled to the possession and enjoyment of the whole property, meaning if I have half, you have half, both of us have the same rights to enjoy the land, okay? To enjoy the whole land. You cannot say, I can only enjoy the left side and you can enjoy the right side. It doesn't work that way. So what happens if one of the co-owners dies or passes away? Let's say there are two owners, all right? Me and you. If I pass away, my share does not go to you. My share goes to my representatives, my personal representatives, meaning the people under my will, my offspring, my spouse, family members, whoever takes over my estate under inheritance law. It does not go to the other person. Of course, if let's say I, in my will, bequeath my portion to the other person, if I pass away, then it goes there. But unless this arrangement is made, if one of the co-proprietors pass away, it does not automatically pass to the other co-proprietor. It will pass to the personal representatives of the deceased estate. Of course, in such situations, my executor or the administrator will have to go to court and get the relevant probate papers, representation papers to get the transfer. But the principle is that my share goes to my estate. The original issued document of title, meaning the grant, is retained by the registrar unless otherwise agreed by the co-proprietors. A lot of times this is done. Let's say when you are purchasing a house from a development project, the title will usually be given to one of the two co-owners because there's consent there and there's an agreement there. The issue and recording of copy of titles can be done. That's not an issue. Copies can be used as and when necessary. So these are not big issues. It's just administrative. Okay, I've already explained this. Does not pass to the other person automatically. Now, I mentioned earlier that both owners have a right to the entire property, not a specific portion. So what this means is that any dealings on the land, legally speaking, have to obtain unanimous consent. Meaning if I have a land and shared with my wife, for example, okay, both of us need to agree to sell the land if we want to sell it. Okay, let's not say my wife. Let's take the situation earlier with the business partner. If I and my business partner co-own a piece of land, both of us need to agree before the land can be sold. Legally speaking, both of us have to agree before we can lease the land out to a tenant. Legally speaking, both of us have to agree before we can charge the land to the bank. Basically provide the land to the bank as security for a loan. Of course, the bank, they will do that as well. They also want to protect themselves. So what this causes is that one person can veto the entire transaction. So that's two people. Imagine if there are 4 people, 8 people who co-own the land. One person who does not agree can effectively block the transaction even if the 7 agree. That's possible if all 8 of them remain co-proprietors. So this has caused a lot of practical problems in real life, whereby an asset or an immovable property could become economically underutilized or frozen, especially where it is caught up in inheritance issues. I'm sure some of us here are familiar with it. That's why we're here. These are certain common situations where deadlocks arise. When I say deadlock, I mean a stalemate where, we can't sell the land because one person does not agree. Conflicting intentions. Some of us here know the feeling where, because the land was inherited from our parents or great-grandparents, one person wants to sell the land, but the other 20 don't want to sell. The other 20, they want to develop instead of sell. So that's an issue. Exclusive occupation disputes. We have clients who come to us who tell us, I co-own the land with my 2 brothers, but only one of them is staying on that place, but all of us are paying the quit rent. equally. There's no compensation. He's not paying us any rent. He's not giving us any profits. Or let's say only one person is collecting rent. And then what do I do? Inheritance fragmentation. This is what we've been talking about this whole time. So these kind of situations cause things to be unable to move, resulting in co-proprietorship issues. When it comes to inheritance cases, shares can be very small if it is not dealt with very quickly. So sometimes clients come to us and they tell us, okay, there's a dispute between them and their siblings. They can't decide how the other siblings don't want to sell. This faction wants to sell. That faction doesn't want to sell. So the matter drags on, and several of them pass away and is taken over by their children. So it drags on even more and makes things even more complicated. So a very extreme case is like the Kampong Baru landslide holding dispute, where a single 809 square meter lot is owned by 141 co-proprietors. The smallest recorded share is 7 out of 424, 320,000. This is approximately only like 0.013 square meters per person. And the share is worth only 13 ringgit of that land. So despite this tiny value, each one of these 141 co-proprietors have equal legal rights to the entire land and could block these transactions. So that is why we would always advise our clients, if you have a deadlock situation, deal with it now. Don't wait. The longer you wait, the more complicated things are going to become if there are inheritance issues, if some of the co-owners are advanced in age. If there is a deadlock between co-owners, property value will decrease naturally. Nobody will want to buy a piece of land that, half of them say want to sell, half of them say don't want to sell. If I want to buy a piece of land from you, I want to make sure that I can get the whole land from you. I don't want to sign an agreement with A and then B and C later says they don't want to sell, and then now I've paid a deposit and I've gotten a loan from the bank and now I'm stuck. So if there is a co-proprietorship issue, the land's value will decrease. Your ability to sell the land will decrease. It's less attractive. Banks are also reluctant to accept or finance properties with unresolved co-proprietorship issues. And land disputes, I can personally tell you from my own experience, lead to family conflicts. So I want to get it sorted out as soon as possible. How can we terminate co-proprietorships then? Okay, let's say, Joseph, I'm stuck in such a situation. What do I do? There are two ways to go about it. The first way is to negotiate a settlement, to negotiate an agreement between all the co-proprietors. This could include partitioning of the land. This could include transfer of one person's share to the other. That means me and my business partner, we come to an agreement to say, okay, you can have the land, you pay me a sum of money, I will give you my half share, and then you take it and you do whatever you want. Or we can both agree to say, okay, we will get a registered valuer to value the market value of the land, and we will all agree to sell the land at this market value. And then the proceeds will be distributed according to our share. And that is the way of mutual agreement. That's how we can settle the dispute between co-owners without going to court. That is also the most cost-effective and the most headache-free way. It still involves several legal steps, but at least you don't have to go fight it out in court. You don't have to take the witness stand. You don't have to get the land caught up in the legal process for a long period of time. When there's a court, when it's deadlocked and you cannot resolve it amicably, parties cannot manage to negotiate a settlement, then the parties can go to court to terminate the co-proprietorship. That means we stop this co-ownership, let the court decide what to do. Partition the land or subdivide the land, facilitate the transfer of shares, or order the sale of property and terminate the co-proprietorship. The court can do that. So before we go into the court cases, some technicalities, partition is that where the land is separated into individual titles. Remember our conversation on titles earlier. Each person gets their own garant, gets separate titles, so we don't have to fight over one single title. Easier to transact, easier to do business with. Each owner becomes the sole owner of their own portion, and then there is no longer co-proprietorship. This is generally the simplest and most cost-effective option. Including sale is also easy, but all this depends on human relationships. So this is where sometimes good legal advice can help you determine what approach you want to take, how you want to negotiate, how you want to structure your negotiation, what bargaining chips you have and all that, all right? Partition is subject to approval by the land office. It includes planning and development requirements, meaning where this land is fall under industrial zone, commercial zone, residential zone, land use and restrictions. Agricultural land cannot be partitioned smaller than a certain area, compliance with local authority regulations, and consents were required by law. Meaning in your title, if it requires state consent, then you have to get state consent. All these are administrative in nature. Usually it's not an issue. So under Section 141 of the National Land Code, partition can be done and ensures co-proprietorship disputes do not completely block resolution. So this comes under the purview of the land office. So you can apply to the land office for partitioning, but it's at the discretion of the land office. Because land law is under the state jurisdiction, each land office has their own set of requirements. Each land office may have certain minute changes in their procedure. So we need to be aware of that. Partitions must not contravene zoning laws, planning authority requirements, or minimum area restrictions. So if it's zoned for a agricultural area, the partition cannot make it smaller than a certain size, which is it cannot be smaller than the statutory minimum of 0.4 hectares. So a 1 hectare agricultural parcel, for example, cannot be partitioned into 4 lots of 0.25 hectares each. That would violate the legal requirements. That cannot happen. So in such a situation where the law or local regulations of the land office does not allow for partitioning to happen, co-proprietors will need to consider a buyout, transfer of shares, or sale of the land, negotiations, other forms of settlement, or go into court. So that is basically the legal framework of how co-proprietorships work in Malaysia. And that is the ways and the options available to you where you want to terminate a co-proprietorship. So when you're stuck and you need to get out of this stuck situation, this is the legal framework that we are working with. So I will pass the time to my colleague Kirtana to take us through some court cases which have dealt with this issue and see how the courts deal with it. In the event that you need to go to court, these are some cases which we can look at. These are some cases which you can study to see what principles we can take out of that. I will come back to wrap up at the end, but for now, I'll pass the time to Kirtana.
Thank you, Joseph, for explaining the practical challenges that arise when land is held in undivided shares, particularly the deadlocks that can occur between co-proprietors. I will now discuss the legal remedy available when those avenues are no longer viable, specifically an application to the High Court under Section 145 of the National Land Code. In this segment, I will also explain the circumstances in which the court intervened to terminate a co-proprietorship, the principle established by the leading authorities in the area, and what co-proprietors should take note of when seeking the court's assistance to resolve a deadlock. So, under Section 145, subsection 1 of the National Land Code, the court may intervene where a co-proprietor refuses to consent or cooperate in a partition, or where statutory requirements prevent a normal partition from being carried out. In either situation, this results in a deadlock between co-proprietors. Where a deadlock arises between co-proprietors, the issue then becomes what follows. And as Joseph has explained, there are situations where the usual administrative route is no longer available. This may be because one co-proprietor either refuses to cooperate, or refuses to sign the necessary documents, or simply cannot be contacted. In other cases, the land or property itself may not be capable of being partitioned under the requirements of the National Land Code. When that happens, the deadlock does not mean that the property must remain stuck indefinitely. Section 145, subsection 1 of the NLC provides a solution. Here, we can see that it allows any co-proprietor to apply to the High Court and seek the court's assistance in bringing the co-proprietorship to an end. In other words, where the parties cannot resolve the issues themselves, the court has the power to step in and determine the most appropriate way moving forward. The important point for co-proprietors to take away at this stage would be that you are not left without a remedy simply because another co-owner refuses to cooperate in how to deal with the land or property moving forward. The National Land Code provides a mechanism for the court to intervene and break the deadlock. So what exactly can the court order once its jurisdiction is invoked? Well, that brings us to Section 145, subsection 2 of the NLC. Section 145, subsection 2 gives the court a fairly wide discretion to bring the co-proprietorship to an end. And in practice, the court usually moves forward one of three main types of orders. First, the court can order a partition of the land. In effect, here, the court can treat the application as if it has been made by all co-proprietors and direct that the land be divided accordingly. Second, the court may order a buyout of shares. As again explained by Joseph earlier, the court can make an order where one or more co-proprietors are required to acquire the undivided shares of another co-proprietor and on terms that the court basically considers fair. And third, where neither partition nor a buyout is suitable, the court can order a sale of the property, with the proceeds then distributed between the co-proprietors in accordance with their respective shares. So in simple terms, the court has three practical tools: divide the land, transfer the shares, or sell the property. The appropriate remedy is usually dependent on the specific facts of the case. Now, if we focus specifically on one of the most commonly sought outcomes in this dispute, which would be the sale of the property and or land, the procedural mechanism we can usually rely on would be is found in Order 31, Rule 1 of the Rules of Court. This rule empowers the court in proceedings related to immovable property to order a sale where it is necessary or expedient for the purpose of resolving the dispute. Basically, once the court is satisfied that a sale is the appropriate way moving forward to resolve the co-proprietorship, which has reached a deadlock, it has the procedural power to direct that the property be sold. This provision works together with Section 145 of the NLC, forming the legal and procedural framework that we can take into consideration in seeing how the court is allowed to convert co-owned land into sale proceeds to be distributed among the co-proprietorship when terminating a co-proprietorship by way of sale. Now we must look at this stage, we must look at what does the court consider a sufficient basis to treat a sale as necessary and expedient. In applications involving the termination of co-proprietorship, this phrase represents a key threshold that the court applies when deciding whether to order a judicial sale. The Malaysian courts have recognized that a genuine factual deadlock between co-proprietors may constitute a sufficient basis for a finding that a sale is necessary or expedient under the Order 31 Rule 1 of the Rules of Court. Put simply, the court is not confined to cases of legal impossibility or extreme hardship. A practical breakdown is sufficient, such as an inability to agree on the use, management, or future of the property that is owned by the co-proprietors, where the relationship between co-proprietors has fundamentally broken down to the extent that the property can no longer be effectively managed on a collective basis, the court may consider a sale to be an appropriate mechanism. I would say that this reflects the court's broader approach in co-proprietorships, disputes that co-ownership between parties should not be allowed to continue once it becomes unworkable in practice. Now, I will briefly run through a few key Malaysian authorities to illustrate how the courts have applied Section 145 of the NLC in practice. I will not go into excessive details for each of these cases in the interest of time, but instead, we'll look at how we can highlight the practical principles the courts have developed when dealing with the deadlocks between co-proprietors. The first case we will be looking at is Ong Chin Hai. The property in dispute in this case formed part of the party's late father's estate, and following the administration of the estate was registered in the names of the siblings as co-proprietors. Each sibling had an undivided 10% share in the land. And as Joseph mentioned earlier, ownership in undivided shares means that although each co-proprietor owns a proportionate interest in the property, no individual owns any specific portion of it. There's nothing to say that we can distinguish which part is owned by which party. The dispute later arose when some of the siblings wished to sell the property while the others did not consent to the said sale. Faced with such a deadlock, the respondents, who were the plaintiffs at the High Court, this is a Court of Appeal case, applied directly to the High Court for an order for the sale of the property so as to terminate the co-proprietorship. The High Court granted the order. The appellants, who were the defendants at the earlier instance, appealed the decision on several grounds, including the argument that the respondents had failed to satisfy the requirements under Section 145, subsection 1 of the NLC. So then the central issue before the court in this case was whether the co-proprietor seeking to terminate the land under Section 145 must first apply to the land office for a partition of the land and have that application be rejected before approaching the High Court for any order for sale. The Court of Appeal in this case made it clear that there's no such requirement and that Section 145 is an independent statutory remedy and that a co-proprietor is not required to basically exhaust or be rejected from administrative partition proceedings before invoking the court's jurisdiction. So this case is therefore significant for us to look at because it basically removes any procedural barrier and reinforces Section 145 as a direct remedy to resolve deadlocks. The next case is Ko Bo Huat. This case deals with a situation where partition was not merely inconvenient but legally impossible. In this case, the plaintiffs collectively had held a 9/10 majority share in a piece of agricultural land. Ordinarily, co-proprietors who wish to end their co-ownership may consider partitioning, as we discussed earlier. However, when partition cannot be effected, because in this case, as we can see, as I mentioned earlier, it's an agricultural land. So then it would have resulted in parcels that fail to comply with the minimum lot size requirements imposed by Section 141 of the NLC. As a result, the usual avenue of partition was unavailable in this case. The court in this case held that where partition is not possible due to statutory restrictions, it is appropriate for co-proprietors to invoke Section 145 of the NLC to terminate the co-proprietorship. The court therefore then ordered that the property be sold by public auction, despite the objections of the minority co-proprietor. This case basically demonstrates that the court is prepared to intervene where strict adherence to unanimous consent would result in an unfair or unworkable deadlock, basically holding parties at a standstill where you simply cannot deal with the land in any way. It confirms that Section 145 serves as an important mechanism for resolving situations where co-proprietors are unable to effectively deal with the land. The third case, Kumaradevan, arose from a family dispute involving a mother and a son. So this is basically a bit more personal, where it involves an actual family dispute where I believe this case prolonged over a few years. So the mother and son jointly owned a property in Bangsa. Over time, the relationship between the parties deteriorated to the point where it was no longer possible for parties to try and deal with the land even by consent. So the mother, the defendant in this case, stayed in the property and basically refused to cooperate with any proposed sale, resulting in a deadlock of the property. The court here found that partition was impracticable due to cost, planning constraints, and the nature of the property itself, and that continued joint ownership of said property was simply untenable. The High Court here held that a sale in this case was both necessary and expedient to resolve the existing deadlock and consequently order a sale by way of public auction. The court even went as far as to ensure the enforceability of this order by authorizing the senior assistant registrar to execute documents if the defendant, the mother in this case, had refused to cooperate. This case demonstrates that where co-ownership has become so unworkable in practice, the court is prepared not only to order a sale, but to also ensure that the sale can proceed despite resistance from a uncooperative co-proprietor. The final case that I will discuss is Shu Chai. This High Court case dealt with a situation involving former business partners who are also co-proprietors of a property, with related arbitration proceedings that were still ongoing in regard to said property. So the defendants here resisted a sale and argued that the property could not be dealt with due to the pending arbitration, and instead insisted on being paid a fixed sum for their share. The High Court rejected this position and held that the existence of a clear deadlock simply empowers the court to order a sale. The court in this case basically reaffirmed that even where Section 145 of the NLC is not strictly invoked, the High Court retains the jurisdiction under Section 25, subsection 2 and paragraph 3 of the schedule to the Courts of Judicature Act, read together with its inherent powers, to make orders necessary to meet the interests of justice. In appropriate cases, this includes the court's power to order a sale in lieu of partition and to make consequential directions required to give effect to such an order, particularly where continued co-proprietorship has become impracticable. The court also further clarified that the existence of a bank charge, which is specific to this case, does not prevent a judicial sale, as the outstanding financing can be redeemed from the sale proceeds before any distribution to the co-proprietors. The key takeaway would be that from this case is that neither parallel proceedings nor existing financial agreements will prevent the court from ordering a sale where the co-ownership has reached a genuine deadlock and the court considers it necessary and expedient to make an order. In essence, the cases we have looked at demonstrate a clear and consistent judicial approach to co-proprietorship disputes. Taken together, Section 145 of the National Land Code, along with the Courts of Judicature Act and Rules of Court, operate in practice as a practical mechanism for resolving co-proprietorship deadlocks. I will now pass the session back to Joseph to take us through the litigation roadmap and conclude the presentation. Thank you.
Okay, thanks, Kirtana. We will now look at a few practical tips, all right, when it comes to co-proprietorship disputes. So in dealing with co-proprietorship disputes, as Kirtana has described earlier, and as Kirtana has taken us through several court cases, there are several things that we need to prepare, or several things that we need to be prepared to do before engaging in court proceedings for termination of co-proprietorship. First thing we need to bear in mind is we will need to engage the services of a valuer. So the services of the valuer need to be engaged because we need to get, most of the time, we need to get someone to determine the value of the land. And that can only be done by a licensed valuer. And then it will be accepted by the court. Lawyers can't do that for you because we are to deal with the law. Land value, you'll need to get a licensed valuer to do. And then as a matter of prudence, it's good to issue a notice of intention to sell or resolve the co-ownership. So basically, you have to show that you have taken steps to talk to everybody and everybody is not willing to cooperate. Otherwise, the court will, or the judge will just tell you, go and talk among yourselves first before you run to court. So you need to make efforts to resolve the co-proprietorship before going to court. Refusal or silence from the other co-proprietor may evidence a deadlock. So, for example, I can't reach you. I've sent you messages, I send you emails, I send you letters. You don't want to respond. That could be an evidence of a deadlock, okay? But you have to take steps to do that. This ensures that eventually when you go to court, you have your evidence with you so that the court or the judge will more easily grant you the order. All right. When it comes to commencement of proceedings, a lot of cases, when it comes to termination of co-proprietorship, are done by way of originating summons. In plain language, what that means is we don't have to go for trial. Everything is done via documents. Because usually the case is, I want to sell, you don't want to sell. He wants to sell, she doesn't want to sell. So 4 of us want to sell, 1 person doesn't want to sell. What is that to say? There's no point to going to trial. Everything is documented, that's it. But in cases where things can get a little bit more complicated, where somebody is alleging fraud, that is when it may be converted to a writ action, which means you have to go for trial, you have to examine witnesses, people have to be put on the witness stand. But in most of the cases, trial is not necessary or not strictly necessary. All right. The court may grant an order for sale where sale is necessarily expedient, where sale is the best option. The court may issue consequential directions, including appointment of auctioneer, fixing of reserve price, and distribution of sales proceeds among co-proprietors. The court has a wide discretion, as Kirtana explained, to issue the necessary orders to ensure that the co-proprietorship is terminated and to ensure that all parties are treated fairly. Court may ensure safeguards or ensure compliance by issuing directions. A lot of times, this will take the form of a penal notice in the order. So let's say my faction against the other person's faction. So I win in court and the court has directed everyone to sign, meaning the other side must sign the documents. Because when it comes to transactions on land, we still have to get documents signed and submitted to the land office for processing. So let's say faction B, the losing party, does not want to sign. There are several ways the court deals with it. Number one is an endorsement of a penal notice on the order of the court order, meaning they say that if you do not comply, they can take action against you by way of committal proceedings or contempt of court. Contempt of court involves fines and even jail if it's serious. So by putting a penal notice, by issuing a penal notice on the order, the court is effectively telling the losing party, you better comply. Otherwise, you'll be in personal trouble. The second way the court can do it is the court authorizes the registrar to sign on behalf of the losing party or the party who does not want to comply. So the court says, okay, sell the land. Okay, the winning party, we have all signed. The losing party refuses to sign. So we can write to court to say, okay, court, look, the other party refuses to sign the sale documents. Please get your registrar to sign on behalf of them. So the court can do that. The court can authorize the registrar, the court registrar or court officer to sign on behalf of the losing party, which refuses to comply. But of course, in that situation, you have to first show that you have asked them to comply, you have given them the documents and they refuse to comply, then you say, the evidence that they refuse, you take it to the registrar and say, registrar, please sign based on the court order. So this is usually how enforcement is done. Okay, so that's basically a few tips when it comes to litigation. Note that there are questions here. I will stop sharing first and we will be taking questions from the floor. Okay. Now, if a property held under a Sediran Berhad is held under a company and the property is unable to be rented out, or so this is a question from Christine, and the property, you can't rent it out or you can't sell it, can the company write off the property and subsequently strike off the company? The directors do not want to take over the property. Now, the answer is no, the company cannot do that. Why? Okay, I assume by the language of your question, you understand what striking up is. So if you look at the SSM's guidelines to strike off a company, the second guideline itself is that the company has no assets and liabilities at the time when the application is made. So if the company has assets, meaning they have a piece of property under their name, SSM is not going to strike off your company. Striking off is a discretionary measure that is up to the registrar of companies, that means SSM to deal with. If the company has assets, the registrar is not going to strike out the company. And you can't write off the property as well because it doesn't work that way. You can't write off ownership of a property under Malaysian law. So what you have to do in these situations is you can't strike off the company, but to close the company and deal with the property, what you have to do is wind up the company. So you don't apply to SSM to strike it off, but you have to commence winding up proceedings. When I say winding up proceedings, it doesn't necessarily involve court. You can go by way of a member's voluntary winding up as well. So in which case, you have to declare solvency. The members will have to, shareholders will have to pass a resolution to say, okay, we're going to all wind up this company. And in that situation, the liquidator will come in and liquidate the assets. And then whatever proceeds will be divided amongst the shareholders in accordance with the shareholding. Of course, there are other nuances under company law, but for the purposes of answering this question, no, we can't strike off the company if there is a property. You have to go, if you want to close the company, you have to go by way of winding up. Okay? The question from an anonymous attendee, what happens after the court orders the sale? What documents to file? You just have to file the court order. You file the court order. Basically, when you ask the court, you file the case, you'll have your prayers. That means what you are asking from the court. And the court will grant you your prayers, or the judge will look at your prayers. The judge will look at what you're asking and say, okay, I give you number 1, number 2, number 3. So you will file your court order into court, and then you extract, the court will seal the order. That means the court will chop the order, endorse the order, and then based on the order, you prepare your sale documents, meaning your transfer form, your SPA, and everything. So once you prepare all those documents, you take those documents and the court order, you go to the losing party and say, now you sign everything, okay? And if they refuse to sign, depending on what your order says, you can either take it to the registrar and say, okay, look, they don't want to sign, please sign for them. Or you enforce the committal. You say that you're in contempt of court, I summon you to court, and you explain to the judge yourself. Okay, these are a few things that can be done. But essentially, if it's a termination of co-proprietorship situation, all you have to do is file the order, and then you get the necessary transaction documents and get them to sign. Unless, of course, if the court orders an auction, even if the court orders an auction, you don't have to. Usually there's not much documents to be filed after you get the order. If there are other consequential orders like, payment of money and everything, then you can file enforcement proceedings like judgment, debtor summons and all that. But for the purposes of answering this question, the straightforward answer is basically just that you file your order, you get your transaction documents, you get the other party to sign. That's it. Can you impose Section 145 to get an order for sale to divorce for a divorce case? Yes, can. Usually in matrimonial proceedings, the court will make the order directly. But if there's none, then parties can invoke Section 145 to ask the court to terminate the co-proprietorship. Yes, but there are nuances because when it comes to divorce, family law is involved. That has to be weighed against the family law considerations. Short answer is yes, but the long answer is you have to look at the case first to see what are the appropriate steps to take. But short answer is yes. How can the liquidator dispose of the property to sell it? What if unable to do so? The liquidator not usually, almost all the time can dispose of the property. The disposal of the property may not be at the price that is the best price, but the liquidator most of the time will be able to dispose of the property. It will sell the property and auction the property under value. There will almost certainly be a buyer. But of course, when you dispose of it, it's undervalued because if you are not able to sell it at market rate, then the liquidator will dispose of it via auction and whatnot, and that means it's under market value. But the liquidator will be able to do it. They are experienced in doing these kind of things, so they will have the liquidators will have their contacts as well, and you can trust them to get it done. It depends. Also, if your liquidator is the Jabatan Insolvency, then that will take forever. But if you get a private liquidator, then there shouldn't be a problem. We have a few questions in the comments as well. Let's see. Will one valuer be engaged on behalf of all the owners? Who will select the valuer and when? It depends whether or not you're going for a court situation. When you're going for a court situation, what you will ask the court to do is get a valuer appointed by party A. Usually if the court says party A is right, then the court will grant that order. So one party can engage their own valuer. Or if the court says, no, you have to agree on a joint valuer or a valuer that is appointed by the court. That is also possible. So it depends on the circumstances of each case. But most of the time, the court will order both parties to say, okay, you have to sell. I don't care. You cannot not sell. But what I give the losing party the liberty to do is to agree on a valuer. So both parties have to agree on a valuer that both parties are comfortable with. That is what happens most of the time. Your second question, Tanisha, essentially the answer is that the court will look at whether or not there really is a deadlock, and the fairest outcome for both parties is the termination of co-proprietorships. We will not go into a very deep legal discussion doctrine here for the benefit of all our attendees, but essentially the main consideration is whether the outcome is just and fair to everyone. If you want a deep dive into legal doctrines, we can go into the textbooks and all that on another occasion. Okay, that's all the questions we have for today.
Thank you, Joseph and Kitana, for the valuable insight on today's topic. Before I conclude, I have a few announcements to make. First, please join us again for upcoming talk, sexual harassment, complaint in the workplace, managing risk, compliance and tribunal proceedings, which will be taking place on 24th June 2026. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Do follow or like our social media account. Fourthly, if you'd like to speak with our lawyers, we offer a complimentary consultation up to 30 minutes over the telephones or over video conference. Please fill in the form on our website. The link is posted in the chat box as well. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you everybody, and see you at our next talk.